With us now, attorney Andrew Lieb. Thanks for joining us tonight. There are several other cases that were referenced in this draft opinion. The cases legalized same-sex marriage, access to contraceptives, interracial marriage, integrated schools. The list goes on. In your mind, are these cases really all that similar?
They're all similar in the framework of which they wrote this new opinion. And what I mean by that is they all come down to a privacy right that we find from the word liberty in the 14th Amendment. You see, they're not expressly written in the Constitution. So many readers of the Constitution will say, oh, well, those aren't rights. But we've always understood, at least since Casey was decided, which is the case that upheld Roe v. Wade, that you see, there's fundamental rights that go back in time that we understand to have. And as you mentioned, things like having contraceptive or same-sex marriage, or even the fact that the government can't make it illegal to have sodomy. Different items that we hold true to make our own personal decisions. Now they're all out the window if this Alito decision holds up.
And Justice Alito wrote this draft opinion. It's 98 pages long. For our viewers out there who maybe haven't had time to read all 98 pages, I'm wondering if you can summarize his arguments and why does he think Roe was wrongly decided and worthy of being overturned nearly 50 years later?
He basically says that this is not a right to have a choice for abortion that is written into the Constitution. And then what he says is, listen, in order for it to be a liberty right, a privacy right, it has to go back historically to the beginning of the Constitution. He references Justice Ginsburg, who we all know is one of the biggest advocates of women's rights, and he says her own analysis of privacy rights looks back to history. And then he says, but there is no history for abortion, that it's a constitutional right.
So during their confirmation hearings, we're hearing a lot about this today. Justices Gorsuch and Kavanaugh seem to reaffirm their belief that Roe was precedent and shouldn't be overturned. Take a listen.
It is a precedent of the United States Supreme Court. It was reaffirmed in Casey in 1992 and in several other cases. So a good judge will consider it as precedent of the United States Supreme Court, worthy as treatment of precedent like any other.
As a judge, it is an important precedent of the Supreme Court. By it, I mean Roe v. Wade and Planned Parenthood versus Casey. Been reaffirmed many times. Casey is precedent on precedent, which itself is an important factor to remember.
Now, Senator Susan Collins brought this up today in her statement. This draft opinion, if they end up supporting it, is not aligned with what they said. Is there any consequence for that?
Well, there's political consequence for sure. She went further, though, Senator Collins, and she said it wasn't just during their hearings, but in her private office meetings with them, that they reassured her that they would follow the precedent. And I think the major consequence is something that you and I are saying, and it has to be overtly said to everyone. Abortion is groundbreaking. That's something that changes everyone's opinion. The fact that we have a leaked decision, that's groundbreaking. But the biggest decision of them all is what Gorsuch and Kavanaugh just alluded to. By not following precedent, which means prior decisions, the Supreme Court has taken itself out of being a systematic body and become much more of a political body, where arguments before the court need to go now to the hearts and minds of the justices, as opposed to analyzing based on prior decisions. The stability, the integrity of our Supreme Court is what's now in question moving forward.
Certainly a lot to talk about moving forward. Andrew Lieb, thank you so much for being with us.
Such a pleasure. Thank you.